Hey guys, Troy from theSPACE. I am here with Donna Patane from MacDonnells Law. Hey Donna.
Hi.
So this is a part of an ongoing series of masterclass, and today we are fortunate enough to have Donna here with us to talk about legal structures. Really important to be across these or aware of these whether you started out or you've got an idea and you're just about to start out, whether you're some way down the path and you're thinking, oh, sugar, I should have done something about this, or you're a fair way down the path and you're looking to restructure. So all very relevant. Thanks for tuning in. We'll try to keep this short, sharp, and powerful. So I'm going to throw to you, Don.
Yeah, sure. Thanks for having me.
Pleasure.
Okay, so I deal quite a bit with startups, people who are along this journey, and quite often at some point we'll have this discussion about what kind of legal structure they're currently using, and whether that needs to be massaged or whether that needs to be replaced and things fixed up entirely. So this is the kind of information I usually use, and I've done it as a case study so that we can put names into it and get a better idea, feel for how things fall together. So my case study is Leonard Bain, which is probably the most boring name I can think of. He's invented, we're just pretending he's invented a keyless entry mobile app. The IP has been protected. So Donna's not going to talk about that today because that would be like a whole hour.
That's a different masterclass that we'll do.
Definitely. Yeah, so we just got to skip over that step for now. Before he takes his product to market, he needs advice on his business structure to make sure it's all hunky-dory before things take off and go awesomely well.
And is this to protect the asset, or is that to what's the key thing there?
A lot of things. It's to protect. Yeah, that's probably like my next slide. It's to take into account. These are probably the top
here we go.
8. So control. Who is going to have control with how things progress? Ownership. Those two things can differ sometimes. Who's the owner of the business or the company or the IP? There's always tax to consider, and if you talk to your accountant, certainly that will be sort of number one on their list, minimizing tax, because you're going to earn lots of money and you don't want to give it all to the ATO. Probably the biggest one for the lawyers is asset protection. So if the mobile entry app causes some kind of liability and you get sued, you want to make sure that your personal stuff isn't up for grabs, but from anyone who's trying to recover financially from you. Transfer duty is a big thing, and that's certainly a big thing the longer you leave it, because the more you build up your business and the IP and the products, the more value there is, and therefore when you're transferring it between structures or selling it, duty can suddenly become quite a big cost.
Because you're the owner or the founder of the business, and if you set up a company, it's a separate structure, isn't it? As opposed to a sole trader where it's still you as the person.
And that's generally how most people will start. If you start playing with that, technically the business and the assets are being sold from you sell yourself to your company, and there's a duty consequence.
Even if you own 100% of that company, because it's going to a different entity. And that means you have to pay stamp duty.
Which is money for nothing. So we don't.
So timing is important as part of this.
Definitely. The longer you leave it, the bigger the business is, and the better things are going, the more the state revenue will take duty from you.
And how does that calculate through an accountant?
No, well, we usually do that as well, just as part of a transaction. The other things are complexity and compliance. So what kind of structure you're using will determine how complex it is and what kind of reporting you need to do to ASIC or anyone else. And one of the big ones for startups and scale-ups as well, is begin with the end in mind. So are you hoping to build up this business and use that as your sole income and make yourself a good retirement fund and then sort of continue on that way? Or is it something that you want to develop really quickly and sell off really quickly and get out and take the money and laugh all the way back to the bank?
So more like a startups scale-up concept.
So
the consideration there is also with in terms of structures, ensuring that the IP, but there's consideration of where that IP sits in the structure as well, if you're for investment, for example.
That's right.
Because investors want to make sure that they're investing in where the IP is at.
Definitely, because that's usually where the value is.
Exactly.
So then in terms of the options, these are the 5 main options: a sole trader, a partnership, a private company, public company, or a trust. So we'll talk about each of those in a bit more detail. So the sole trader, as I say, is just you yourself carrying on your own business. Leonard's probably got his business name registered through ASIC nowadays. So it's just Leonard training as
That's about
Technology.
$36, $38.
Yep. For 3 years, I think it's about $13 for 1 year.
Oh, is it? Okay.
Super cheap.
It's
Really
not
easy to do. Do it online.
ASIC.gov or Google that.
Yeah. Create an online account, fill out the info. Really easy to do.
And they also help you to highlight if there's already something that's too close to that, so you can't register.
Yes, yeah. They'll apply a slightly different rule to what IP Australia would do in trademark land, but that's a whole other story.
Yep, cool.
Okay, so the pros and cons of your sole trader are, it's really cheap and easy to set up. Jump online, do it yourself. It means that Leonard will have complete ownership and control. He's entitled to all of the profits and the assets. It is smaller than the other business structures, so it's pretty low on the complexity and compliance requirements, pretty easy to operate. You do your own tax returns, that sort of thing. The cons are, because he's got all the benefits, he's also got all the liability. So if something goes pear-shaped, Leonard would be sued personally for any issues. He's the one signing the contracts, and he's personally fully liable for anything that happens. Therefore, he's at risk of losing personal assets, including the IP, because it would all be in his name. And from the accountant's perspective, there's less tax perks, concessions, etc. for individuals. Whatever you earn, you just pay tax at your individual rate, which might be fine when you're in like baby startup land and it's not earning a whole lot, but that's not everyone's plan, right? The plan is to earn a lot more, and therefore you'll end up ticking over into those higher tax brackets.
Yep.
Partnership is the next one, and partnership is you've got someone else involved. So in my example, I've introduced David to the mix. But you can have more partners than that. You can have 4 or 5 or 6 of them, and this structure will still work sort of the same way. So a partnership is not registered anywhere. It sort of comes about by 2 people working together under a partnership agreement. And a partnership agreement is one of the sort of founding agreements I generally refer to, in that it's a document that sets up the rules that have been agreed for the dealings of the parties involved. So Leonard and David had a partnership agreement that says, here's our initial contributions, here's what Leonard's going to do, here's what David's going to do, here's how we're going to deal with the profits. If we need more capital, here's how we're going to put that in. And really importantly, what happens if someone wants to leave? And how do we work out that process? So because there's no registrations and it's fairly low on the compliance perspective, it's pretty cheap to set up. I would definitely recommend having a lawyer involved to do your partnership agreement though, because a lack of a partnership agreement or a dodgy online partnership agreement would make a lot of fun for a litigation lawyer if things go pear-shaped, because it won't have the content that you needed to have to prevent those issues down the track. So if it's done properly at the front end, everyone's clear on what they need to do, you've got all your processes set out, it really will stand the partnership in good stead moving forward.
Yep.
Whether it all goes pear-shaped or someone just wants to work on something else and leave, amicably.
In my experience, not so much with this, and I'll probably, actually, I'll wait until we talk to you about the companies.
Yeah, okay.
Because I think that there'll be similar reasoning of why it's important.
Definitely, yeah. Because relationships, you've got other people involved.
People, the humanness of it all. Yeah.
Okay, so there's a co-ownership and a share of responsibilities, obligations and risks. They can create a trading name, so the partners can hold Bain Technology as the trading name. There's no issue there. In terms of the cons, each of the partners is responsible to pay the other's debts. So they're both sort of jointly and separately liable. There's tax implications in that, not so many perks because you're still both paying at your individual tax rates, and huge risk of breakdown of the business relationship between the partners and, things tumbling further if you don't have a decent partnership agreement in place.
Yep.
One of the other important issues with partnerships is that partnership law says that either of the partners can legally bind the other to, or the others, if there's multiple, to a particular arrangement. So if David goes a bit rogue and starts signing the partnership up to supply contracts or whatever, the partnership and the other partners are bound.
Yeah,
so if you got someone that's maybe prone to be a bit rogue,
a bit loose,
maybe consider one of the other structures.
Cool.
So the next one is the private company. So that is your name, BH, I've used Pty Ltd. It's a separate legal entity in the eyes of the law, so it can operate on its own, just like an individual. It has all the same rights. It can sign contracts, it can hold insurance, all that sort of stuff. It's limited liability in that generally, if something goes pear-shaped, the complainant or plaintiff would sue the company, and Bain and Haines liability is limited to whatever they have paid in for their shareholding. The exception to that is if you provided personal guarantees, because then you have personally put your stuff on the line by guaranteeing the conduct of the company. A registration of a company is done through ASIC, it's done online. It's fairly straightforward, although it's going to ask questions that people might find a little tricky in terms of director, shareholder, types of shares, number of shares. So it might be useful to get advice on those kinds of things. Once it is registered, it's an Australia-wide entity, so your company can do anything throughout Australia and has the same rights in any of our states or territories. It is governed by the Corporations Act, but also by a constitution, which is what the shareholders sign up to when they, and the directors as well, when they become part of the company, and a shareholders agreement, which is another of those founder agreements that I referred to. And it's really about the dealings between the two shareholders, Leonard and David.
Could I just clarify? So, constitution and the shareholders agreement, they don't. If you were to go and register yourself on ASIC for a company, the shareholders agreement is not standard, and neither is the constitution. So that would be something that you would have to define, put together, or get expert advice.
Well, they're legal documents, so certainly it's worth having a lawyer involved who knows.
100%.
When we're involved, generally the constitution will stick to fairly traditional types of arrangements in terms of the types of shares and how they are issued and redeemed and things like that. And the shareholders agreement will be more bespoke and will cover off the specific contributions of the parties, rules around the direction of the business, what they're working on, how decisions are made day to day, what's the spending limit on a particular party, things like that. So very detailed, and again, importantly, what happens if things go pear-shaped?
So rules of the game, essentially, like this is how we agreed to play this game. This is what we're agreeing to now, and so if it does go pear-shaped, you've got it as a reference point.
Definitely, and it's a lot easier to do at the front end because everyone gets along and they're all, going to make a stack of money and be really successful.
So similar to a partnership agreement, that's where the value is, like the humanness of it all. Someone has to leave, or we all have other things pulling on our time and attention, and it may be something just genuine, like partnerships drift apart or you got to move away, but then you've got this agreement, well, then you can come back to it and go, all right, well, this is what we agreed on. How do we move forward from now? And they'll generally set out the process. And if there is a process set out, if it's amicable, then maybe it'll be smooth anyway, but if it's not, and usually it's not, the process is there in black and white, including a valuation process, everything. And that's why it's good to have a lawyer to help draft these and put these together, because like you said, often it's not amicable, and the shit is set to fan, and then you this becomes an asset then.
Definitely. And I also find sometimes, because things are going nicely at the beginning, people aren't thinking about those what ifs. So that will generally be the lawyer's role to say, what if?
In my experience now, running an incubator for the last 6 years, is this is as critical as selling a product. Like doing this work is so critical up front, and if you're not doing it, you're putting your business or your idea at tremendous risk. Because I've seen the nasty side of it, and I just want to reiterate, it's freaking critical to get this sort of stuff done up front. It's as critical as trying to sell a product to get money in the bank, because this will bring you undone if it's not done.
So in terms of your private company cons, it is more expensive to set up and to run because you get some reporting through ASIC. The directors will have to comply with the Corporations Act, and there's probably different training or things you can read up to work out what those are, but a lot of that is logic in terms of act in the best interest of the company, don't trade while insolvent, a few things like that. And tax implications, the company does its own tax return and pays tax, but it'll be at a company rate, not an individual rates. And once you start sort of getting up there, you find the company rate is going to do you better than, say, an individual rates.
Yep. Yeah. So just quickly, why would you go a partnership as opposed to a company?
Yeah, if you're going to keep your earnings lower, I suppose, if there's more people involved sometimes.
Yeah.
Sometimes it's a matter of that's kind of already been happening for a while. So we're going to keep it that way because we don't want to deal with the duty of rolling it over.
Yeah.
But we do need some rules in place.
Yeah.
Everything is still going fine, but we really should just
formalize it as a proper partnership.
Yeah.
Okay. And you don't want to pay the duty, yeah. Cool.
Yeah.
All right, awesome.
The next one is the public company. And your public company is BH Limited. It doesn't have PTY in it. It's similar to your private company, but the public company is designed for bigger things, really. It doesn't necessarily need to be listed on the Australian Stock Exchange, but it's the entity that you would need if you intended to do that at some point. So if you wanted to do a massive fundraise and open it up and list it on a public stock exchange. You can have more shareholders, and generally the Corporations Act allows you a bit more flexibility in issuing shares to more shareholders and those kinds of things. You can still have just the 2 directors, or you can start having more with a public company. It's a separate legal entity again. You register through ASIC. It's good Australia-wide. It's governed by a constitution and a shareholders agreement. The shareholders agreements for public companies tend to have less detail because the idea of a public company is for members of the public to come and go, to hold shares and disappear again.
Yep.
It might not start that way. It might start with friends and family, but you've got that flexibility if that's your plans. Usually there's more options in terms of types of shares and shareholding options, employee share schemes, that sort of stuff. It's higher profile than some of the others, and it gives better access to capital, by listing or by having just more movement at that shareholder level. It is heavily regulated. The compliance requirements of public companies is huge. The disclosure you've got to give when you're fundraising is huge. The reason for that is because it's public and anyone sort of can participate. The legislators want to protect.
So it's not just sophisticated investors, it's mum and dad?
Yeah, it could be, yeah. And certainly that's the way the legislation has been done, because it could be those types of investors. Protect them, give them disclosure, all that sort of stuff. If it's listed, it tends to be more volatile in terms of people coming and going and subject to things like a global financial crisis, all that sort of movement. Definitely more expensive to run because of the costs of getting it floated and professional fees and compliance. And you need to make sure that all shareholder interests are taken into account for the running of the company. So decision making tends to be a little slower because you've got to, make sure you're taking into account the right things. You're under, more heavy scrutiny. But you wouldn't generally hit this level unless you're looking at investing, opening for larger investment or listing.
Yep. Cool. Not as common.
No, not as common. The other one, which probably isn't as common either, but I think it's important to mention, is a trust. And I suppose the important point to make there is that your legal entity is the trustee. So the trustee could be led by himself, it could be the partnership, it could be a company, and the trustee is the legal entity. A trust cannot, enter into contracts. It does not have all the benefits. It's not a separate legal entity. It's only the trustee that does all of that sort of stuff. The trust that sits underneath it is put together essentially by a trust deed, and it sets out who your beneficiaries are, as well as what the trustee is supposed to be doing with a view to earning money and looking after those beneficiaries. The beneficiaries can come in a few different ways. More often than not, it's discretionary. So your beneficiaries will be, each of the parties, directors or shareholders, Leonard and David, their wives, their families, any related companies, and sort of broadly drafted like that. The benefit of using this system, the main benefit, is the tax and distribution of income. So when you're structured like a trust, and if you're not already, this would need a rollover, you can filter out your profits the best way to sort of maximise that everyone's income. Yeah, so the trustee would say, okay, we've earned $100,000 in profit this year. but Bob has already earned up to the maximum personal tax rate, so let's funnel it over to Mary or somewhere else, or split it up and have a bit here and a bit there. So certainly a lot more flexibility in terms of what you're doing with your profits.
So often we see people in shareholders agreements that the trustee is the shareholder.
Yeah. So yeah, you can have a play with the different types of structures and how they work together. Excellent flexibility, less liability. Again, your trustee is the entity that has the liability. So if it's a company, then the liability sort of stops there. It is more complicated because you would have, if you're a company, the trustee would have its constitution and a shareholders agreement. Then you would have a trustee to deal with the filtering of funds and how the trust operates. So therefore, a bit more complicated and a bit more expensive to set up. More moving pieces.
Yep.
This next one is what I would consider to be a typical startup structure. So this is one where the startup is not usually done on day one, but where the startup has worked out that their product has legs. It's going to be successful. This is worth spending some money on because we're going to be doing cool things. Generally, we can have 3 entities involved, and most of the time it's 3 companies. They give you that asset protection, and they're still pretty easy to deal with. And, we can take investment and that sort of thing. So generally we'd have one company holding the IP so that it sits off to the side and it's protected on its own. And we make sure that all the IP is rolled over into it and protected as much as we can, registrations, etc. Then there's a manufacturing company which, puts together the widget or app or whatever it is you're working on. And then the business operator. So between the 3, because they're separate legal entities, you need to have documents in place. So the asset holder company needs to license the IP to the other 2 to do what they need to do with it. And the license would include terms to say if something happens to the manufacturer or the business operator, the asset holder can terminate the license. Otherwise, you have issues with, liquidators or whatnot coming in and trying to leverage the same stuff. And then a supply agreement from the manufacturer to the business operator. And then the business operator runs the business, sells the app or the widgets. And if something goes pear-shaped, the complainant or plaintiff would sue the business operator. And the other 2 would kind of shut down and run away. But it means that, the same way if something goes wrong in manufacturing and there's a workplace incident or something like that, the liability and the loss is quarantined in, whichever of the entities that it happens. So it's 3 lots of companies you need to set up and look after. There'd be some duplication in the shareholders agreements and that sort of stuff, but it instantly gives you this separation and ability to quarantine what might be going on.
Yeah, cool. From, I guess, like a lot of the people at the early stage, I'm not sure if you're going to talk about this in the coming slides, but they're probably at the sole trader stage. I'm going to set up a sole trader, and then at some point I might go to a company. And we have addressed this part of the conversation. Start as a sole trader. I know this is how I started out previously, just to get started. But then at some point, when you know that you've got something that's going to be, you've done some level of validation, you want to flip to the company, or I'd suggest a company. Would you suggest?
Yeah, usually.
Yeah, usually a private company. Private company. As relatively quickly, so as to mitigate against any duty that you're going to have to pay. Cool.
That's all I have on that one.
Cool. The other thing that came up was coming back to this one here. Like if looking to raise investment into the business operator, the investors will want to see like an exclusive license from that IP. Otherwise, fundamentally, they're not going to invest because that's where the value is. So that's a consideration as well if looking to raise investment, making sure that license is exclusive. Is that fair to say?
Yep.
Cool. What else would startups need to know? That was really great. Thanks, Donna. Just thinking, like, from the people that I talk to, a lot of people that come into this are, just starting out with an idea, not being in business before. They might have a full-time job, and then this is their side hustle. Yeah. So as a side hustle, like in terms of structures, key things to know, if you do start as a sole trader and get some sort of validation, make sure you move it into a company structure if that's what you're looking at. Fundamentally, if you want to just create a micro business, then sole trader might be fine, but just be aware of the implications of that in terms of the risk profile. But for those people that are looking to potentially take on investment or create a small business to a large extent within a private company would be the better structure to go.
Yeah, definitely. I would say only those who are dealing with a product or a service that has really low risk. So it's something that, if someone's using it, they're not going to hurt themselves or someone else will cause damage or burn down the house or something like that. So if your product or service is low risk and your intention for sales is pretty low as well. So you're selling at the markets on Sundays and you're happy with that and that's what you want to do. Sole trader, I don't think it's any point further complicating it, with the risk issues and low like that. If you've got any intentions on, this is why I say begin with the end one, making it bigger or even, small business as opposed to micro or weekend selling, then certainly earlier on, have the discussion with someone and consider and preferably make it happen, get it into the right entity, because it'll cause you to run through all of the, checklist, I suppose, of what's involved. And it'll mean that any IP you need to register will be done directly in the company name. You won't need to deal with the rollover. It'll mean that your risk issues are dealt with straight away. It'll generally cause you to do a bit more homework on what else is involved with the business.
So in saying that, it makes sense that if you are looking to create something, even if your initial idea is not it, but looking to create something that you think is going to grow, well, then going straight into a company structure might make sense, even if you are the only shareholder and you own 100% of the shares. And you're looking at what, $1,000, $1,500 to set that up?
Set it up.
And that includes constitution, won't include the shareholders agreement, but
but there's an asset fee of about $480 or so. That's included.
That's included in that. Okay, cool. All right. Well, any further questions? We'll post Donna's contact details as part of this video when it goes out. Thanks for tuning in. Any questions? Yeah, I don't know. Any other comments, Donna?
I think so.
All good. All right. Thanks, guys.
Thanks.
Bye.